Thank you. I rise to make a short contribution to this bill. I don't really want to rehearse the detail of the problems with this bill, which has been so ably covered already, especially by my colleague, the Honourable Sarah Mitchell. There is a fundamental problem with this bill. Quite rightly, it recognises what a precious commodity water is and how we need to do everything that we can and we should to make sure that this really important resource is shared for the benefit of the whole community, and anybody who acts outside of agreed community norms has consequences. But those consequences should not jeopardise our basic system of law and our basic system of justice. And unfortunately, with good intentions, I'm sure, this bill just goes too far. The Minister in the second reading speech was aware of the dangers that this could be what this bill does and expressly flagged the fact that civil rights had been considered in the drafting of this bill. I suggest considered and then ignored, because if you look at what this bill does, this bill changes the goalposts for anybody who is involved in using water in New South Wales, and that is a very significant thing for any government to do. I will not be talking about the changes to the really important principle against self-incrimination. They've been covered well, or the changes to the onus of proof. They have also been covered well. I really only want to focus on one thing, and that is the introduction of the civil penalty scheme and its retrospective operation. The introduction of the civil penalty scheme itself is a very curious thing. We already have in this system of regulation criminal penalties, and it is the first time of which I'm aware that a civil penalty scheme has been bolted on to an existing criminal penalty scheme, and in terms of enforcement theory seems to invert the enforcement pyramid. But putting that to one side, let's look at the impact of introducing this civil penalty scheme. A civil penalty scheme which also, interestingly, introduces penalties which are higher than criminal penalties for the same conduct. Now, what's the difference between a civil penalty and a criminal penalty? One of the primary differences is burden of proof. Because of the consequences, a criminal penalty has a higher burden of proof. It's harder to prove than a civil penalty. So what we've got in this bill is the curious situation where we're introducing a civil penalty which will be easier to prove than the existing criminal penalty, but will actually have a higher monetary penalty. This seems a very strange way of proceeding. And the civil penalty regime will be backdated. It will have retrospective operation. Now, the government has argued, no, look, doesn't have retrospective operation because these practices have always been prohibited. The fact that they will be prohibited by a civil penalty regime doesn't change anything. They've always been prohibited. They were prohibited at a criminal standard of proof, and now they will be prohibited at a lower standard of proof. Look, as an example of how this will operate, and it's a trivial example, but I think it makes the point. You incur a parking infringement and you go to court, you argue your case, it's a criminal standard of proof, that standard of proof is not met, no parking infringement. But then the government introduces a new civil penalty regime for parking infringements, and that same action that has already been the subject of a criminal proceedings, which the standard of proof could not be met, that same person faces a civil penalty proceeding and it's a lower standard of proof. So what couldn't be met at the criminal standard is met at the civil standard, and that person under this legislation doesn't even get the same penalty they would have under the criminal penalty. Gets a higher penalty with a lower standard of proof. How can this be consistent with the proper operation of the rule of law in New South Wales? How is it that we can stand here in this place and tell ourselves that we are legislating for the people of New South Wales by dropping the standard of proof and allowing the retrospective operation of this law? And even worse, we generally have a principle of double jeopardy. Essentially, that means that you just shouldn't be able to be continually persecuted by legal process for the same action. If you're charged with something once and done, no double jeopardy. Under this bill, if you have been charged criminally, if the prosecutor has not been able to make the standard of proof, and so no penalty, we can come back. And exactly the same set of circumstances now become subject of a civil prosecution. How can this be an appropriate way to deal with a just legal system? The rule of law requires, it demands of us that if we want a good legal system, everybody must know what their legal obligations are at any given point in time. This changes that. This says 6 years ago, what you had to do to a criminal standard, you can now do to a civil standard. It's changing the goalposts. Now, this may be seen as an effective way of enforcement. What it will do, in real terms, I fear, is create a crisis of confidence in the legal system. Because if the legal system is seen to be unjust, if it's seen to operate unfairly, people lose confidence in the legal system. And that is why the rule of law is so important, because once people lose confidence in the legal system, we start to experience social breakdown. So there's a lot at stake in this legislation. It's not just what is the proper way to manage water resources, it's what's the proper way to run a legal system, what's the proper way to guarantee individual rights, to guarantee rule of law, to guarantee that we are not changing the goalposts on our citizenry. And this bill is not going about that process in the right way. And for this and many other reasons, it cannot be supported.